Kennedy.
Professor, congratulations. I believe you testified that you think the Constitution should be interpreted according to its original public meaning. Is that right?
Yes, Senator.
What does original public meaning mean?
Yes, Senator. So the original part of that phrase refers to the fact that when we look at interpreting a text, we want to interpret it at the time it was.
Professor, look me in the eye and just answer my question. What does original public meaning mean?
It means the meaning that the text as it was understood by the public at the time it became law.
Okay. So you think Brown v. Board of Education was incorrectly decided?
Well, Senator, I think Brown versus Board of Education was correctly decided. Scholars who have looked at the original meaning of phrases at that time and the reasoning in that case sometimes question the reasoning of the case.
How many people in the United States of America at the time the Constitution was drafted do you think supported racial integration of schools? You think that was a majority view, do you?
Well, Senator, at the time.
But first, Professor, do you think that was a majority view? Do you think most Americans at the time the Constitution was drafted supported integration of public schools, racial integration?
Well, Senator, I don't know as a sociological matter what percentage of people thought what at that time. I should point out that when we got to Brown versus Board of Education, of course, there had been several fundamental amendments.
But isn't that inconsistent with your statement that you have to interpret it according to original public meaning?
Well, what about the 14th Amendment and the 13th Amendment and the 15th Amendment? So original public meaning would mean with those, well, that would mean we would interpret those amendments and those protections with the understanding of the text and structure at the time those amendments were ratified, which is different, of course, in the 19th century.
Let's go back to Brown v. Board. Look, I think Brown v. Board was correctly decided, and I suspect you do too. But if you say we interpret the Constitution according to the way that people at that time understood it, do you really think that people at that time in America supported racially integrated schools? Do you really believe that?
Well, Senator, I think at the time of the ratification of the 13th, 14th Amendment, and 15th, all which have.
But do you think people at that time supported integrated schools?
Well, Senator, on that particular question, I don't know it as a policy matter whether they were thinking about that particular issue. I think they certainly understood that the 14th Amendment, for which a massive part of this country essentially lost lives fighting the Civil War, certainly understood it to require racial equality.
You're not answering my question. I'm just trying to understand how you think. It's very easy to say we interpret the Constitution according to its original public meaning, which as I appreciate your testimony, means the way people who read the Constitution at that time interpreted it. Is that right?
Yes, Senator.
Okay. Do you think that most people at that time looked at the United States Constitution and said, well, here it is, big as Dallas, racially integrated schools are required? Do you really believe that?
Senator, I don't know, but
if you don't, I don't think you do, because I think historically that wasn't the case. So how do you square that with the holding of Brown v. Board?
Well, I guess what I'm trying to say is I think there are several steps in between that have not come up yet in our conversation, which is that you look at the text and structure, which of the 13th, 14th, and 15th Amendments clearly is requiring racial equality. And then over time, that has to be applied to different questions as they arise in context. So if the requirement is that all races be treated equally under the law, and the evidence shows that segregated schools is not doing that, then the requirement could be applied to integrate schools.
When you interpret a statute, you talked about interpreting it according to its plain meaning. What if the statute is ambiguous?
Well, Senator, if the statute...
What do you do if it's ambiguous?
If it's ambiguous on the particular question coming before the court, I start with that phrase, but I also look at the context of surrounding provisions.
No. I understand you define ambiguity as the language plus the surrounding language.
Yes.
I get that part. How ambiguous does it have to be? 51% ambiguous or just a little bit ambiguous?
So I have to say I would use the same approach essentially in all cases regardless of the ambiguity, because I would always start with the text, move to the surrounding provisions with the aim of fully understanding what Congress and the President had enacted. And only at that
Professor,
point...
I'm going to run out of time. With respect, answer my question.
Well,
okay, you're giving me professor talk. How ambiguous does it have to be?
I mean, I think under the Supreme Court's recent precedent in Chevron, it underscored that the court can never just rest and say it's ambiguous. The court has to come up with an answer.
Yeah.
So
why don't you just look at legislative history?
Well, you can't look at legislative history statements one by one because
Why
the
not?
individual
Why not?
intent. Well, Senator, with respect, because this body has its role in our system as an institution, not one by one. So your personal understanding of the law doesn't
This will
matter.
be my last question. I'm sorry. Well, Coons went way over. So you're telling me that it doesn't help you at all to go through and look at the congressional record or read the committee reports or any of that? You don't think that's helpful in interpreting what a statute means?
It depends on the way in which it's being read. If it gives helpful statutory history, if it helps to refer to other portions of context, sure, but not to give it legally binding impact in and of itself. I would always be looking at a broad range of sources and use each of these statements as just one piece of evidence about what people understood the statute to mean at the time. So no, I would never take a piece of legislative history in isolation and give it legal impact.
Thank you, Madam Chair.
Thank you.
It ended on a stare and a command. Look me in the eye and just answer my question. Senator John Kennedy, unblinking, leaned across the dais toward the nominee. A law professor turned federal judge hopeful sat beneath the bright, indifferent lights, the oath still fresh in the air, every syllable recorded, every hesitation magnified. What started as a discussion of constitutional method had become a stress test of moral clarity. Original public meaning, Brown v. Board of Education, ambiguity and Chevron, legislative history and the limits of intention. The senator wanted clean lines. The witness offered careful steps. This is how the most durable questions in American law arrive, not in theory, but in confrontation. Kennedy drilled into the heart of originalism with a litigator's precision. If the Constitution must be read as the public understood it at the moment it became law, he pressed, how did a nation that tolerated segregation produce a court that outlawed it? The professor tried to build the bridge in real time, the 13th, 14th, and 15th Amendments, text and structure, a promise of equal citizenship that grew teeth as history revealed where equality was being denied. But Kennedy cut through the scaffolding with the bluntness of a closing argument. Do you seriously believe the American public, at those founding moments, embraced racially integrated schools? The room felt the weight of the question, because beneath it was not simply a clash of interpretive schools, originalism versus living constitutionalism, but a confrontation with our national conscience. What happens when fidelity to the past threatens justice in the present? What happens when what people thought then collides with what rights demand now? The professor answered as scholars do, layered, careful, with the sense that law is an ecosystem, not a slogan. He spoke of text applied over time, of equal protection meeting new facts, of how a principle can outgrow the prejudices that first surrounded it. But the senator returned again and again to clarity, to the yes or the no, to the core tension many Americans feel but rarely see exposed so starkly, whether constitutional interpretation is a moral compass or a museum guide. Brown hovered like a moral North Star. The court's unanimous declaration that separate is inherently unequal did more than end legal segregation in schools. It reshaped the living meaning of the 14th Amendment's promise. Kennedy's challenge was not small. If your method is to read the law as it was publicly understood at the time of ratification, where does Brown find legitimacy? The professor's answer, that the Reconstruction Amendments encoded a demand for racial equality that must govern new contexts, reached for a synthesis, original meaning as principle, not prejudice, equality as text, not fashion, a constitution sturdy enough to confront facts its framers did not foresee. Then came the second movement, statutes, ambiguity, and the search for meaning when Congress leaves gaps. Kennedy pressed again. How ambiguous is ambiguous? 51%? A little? The professor resisted the premise. Ambiguity isn't a dial, it's a condition, and invoked the Supreme Court's retreat from deference, the idea that courts must now do the hard work of reading the law and finding an answer without outsourcing judgment to agencies. Still, the senator demanded footprint and threshold, not atmosphere. He wanted an anchor the public could hold, Legislative history entered like an old character with a familiar argument. Do you reach for committee reports and floor statements? Does it help to search the congressional record for meaning? The professor's reply was a lawyer's balance. Context can illuminate, but it cannot rule. Individual lawmakers' speeches can't become law when the text does not. A nod to separation of powers. A reminder that in a republic, statutes must carry their own weight. What did this moment reveal? That American justice lives in the tension between method and morality. That our judges do not merely recite doctrines, they choose which principles to elevate when the law meets human stakes. Kennedy's insistence on crisp answers mirrored the public's hunger for honesty, not performance, but conviction. The nominee's careful architecture reflected another truth, that law at its best is not improvised outrage, but patient fidelity, to words, to structures, to a constitutional promise that must govern even when it challenges us. It also exposed something about leadership. The senator's demand, "Look me in the eye," was more than theater. It was a challenge to accountability, a reminder that robes and titles cannot hide a judge from the country's questions. Do you believe equality is a timeless command or a historical artifact? When the ink runs short and the text runs out, where do you turn for judgment? To the will of yesterday's public? To the lived reality of today's children? To the bare words? To the beating heart of the amendment that required a war to right? This is the American system, unvarnished. Senators tasked with testing the spine of nominees. Nominees tasked with showing that fidelity to law is not a costume, but a discipline. And the public, watching, measuring whether the promises etched in parchment can still protect real people in real classrooms. In that final exchange, you could hear the country choosing who we want to be. A nation that treats constitutional interpretation like a puzzle with only one solution, or a nation that accepts the Constitution as principle and purpose, binding and alive, more than a snapshot of what the loudest voices believed in a century long gone. Brown v. Board is not merely precedent, it is a moral landmark that tests every method, every nominee, every senator. If an interpretive philosophy cannot explain Brown, cannot honor its result without contortion or apology, it has not grappled with the Constitution's deepest command. The chair thanked the senator. The witness exhaled. The cameras blinked. But the question remained in the air like a verdict not yet read. Do we interpret the Constitution to preserve the dignity it was written to secure, or the prejudices it was born among? On that answer rests more than a judicial philosophy. On that answer rests the soul of equal justice. Here is the truth we cannot dodge. Law is not just logic. Law is a promise. The promise that the words equal protection do not shrink with time, that liberty does not depend on who casts the questions, that our courts will be brave enough to read the Constitution not as an alibi for history, but as a covenant for the future. If you believe that promise is worth defending, if you want hearings that seek principle over posture, courage over choreography, stand with us. This is liberal freedom. Subscribe, share, and support our work to keep the lights on in rooms like this, where the meaning of America is argued, tested, and, if we demand it, redeemed.